were ill-equipped to manage Abu Ghraib and perplexed by what to do with unlawful combatants in Afghanistan. I don't offer our lack of preparation for this long war against radical Islam as an excuse, but rather as the context in which a series of extraordinary poor decisions were made at the Pentagon, the Department of Justice, and the White House with respect to detainees. To the great regret of many of us, the administration pursued a go-it-alone strategy when it came to the treatment and detention of unlawful enemy combatants. Under the rubric of the Commander-in-Chief's inherent authority in a time of war, and armed with the authorization to use military force, which Congress passed in the days after September 11th, the administration implemented policies that were drafted, implemented, revised, and rescinded, and reissued in an endless loop. Interrogation techniques which were supposed to be limited to the Guantanamo Bay may have migrated to Iraq and Afghanistan. The chaos was created by administration lawyers' decision to ignore the advice of our senior military leaders and military lawyers and depart from decades of adherence to the Army Field Manual, the Uniform Code of Military Justice, and the Geneva Conventions. It's hard to fathom that our nation and the world would have to hear the United States discuss documents like the torture memo. Eventually, departure from the time-honored standards of the Geneva Conventions and their well-known and respected rules of restraint were replaced with a new set of untested procedures, which became dangerously and disastrously confused. The alleged detainees' abuse was the unfortunate result. Now, this at Abu Ghraib was not just a few bad apples. Clearly, there were people acting on their own inappropriately in a very perverse fashion regarding detainees. But I think it is best to say that Abu Ghraib was a result of system failure. Mr. Haynes, who will come before the committee today, wrote in an official document that waterboarding may be legally available to the military. Never mind the fact that it is clearly prohibited under the Uniform Code of Military Justice. As a personal aside, Mr. Chairman, one of the great concerns I've had about this whole process is the legal exposure that you place men and women in uniform if they go down this road. The Uniform Code of Military Justice could not be more clear when it comes to the guidelines and guidance provided to those in uniform regarding detainees. We have a very clear policy of non-abuse. Why? General Petraeus said it better than I could. We're trying to be different than our enemy, and I regret the fact that some of our military members were giving advice that would expose them to prosecution if they had followed that advice. The final report of the working group on interrogation convened by Mr. Haynes reiterated an Office of Legal Counsel opinion that in order to respect the President's inherent constitutional authority to manage a military campaign, the prohibition against torture must be construed as inapplicable to interrogations undertaken pursuant to the Commander-in-Chief authority. I would just add that these treaties that we're talking about, the Convention Against Torture signed by Ronald Reagan, have served this country and the world well. And would we sit on the sidelines if some executive in another country said, I have the inherent authority because my nation's at risk to set this treaty aside? Would we object if some airmen were in the hands of a nation state and the executive of that nation said, even though I signed up the Geneva Convention, I believe I have the inherent authority to protect my people to set it aside in this case? If we go down that road, the law means nothing. Regarding detention and prosecution of detainees, we follow a similar pattern. I fought for years with the administration to ensure the policies implemented for determining who is an enemy combatant and who should be tried for violation of war crimes followed the law of war. Here again, the administration tried to play cute with the law and evidence obtained by coercive means and access to classified evidence, just to name two areas. I remember very vividly the initial Military Commissions Act would allow the military jury to receive classified information never shared with the accused. It could be shared with the defense attorney, but not provided to the accused on the theory that it would compromise national security. My belief has always been, what would we do in a trial in some foreign land with a CIA agent or a military member of our special forces or a downed airman, where the trial went forward and the jury or the equivalent thereof was provided information regarding the innocent or guilt of the American in question, and they were never allowed to see what they were charged with or to be able to confront the evidence. What would we do? I think we would object. The Congress was late in exercising its authority in these matters, but the key point is that we eventually did. The passage of the McCain Amendment ensured that this nation would not engage in interrogation techniques that constituted cruel, inhumane, or degrading treatment. The Bush administration fought Senator McCain on the prohibition, but Congress passed it overwhelmingly. The McCain Amendment started putting us back on the road to upholding the best traditions of our nation and restoring our standing in the world. In the same bill, the Detainee Treatment Act, the Army Field Manual became the standard for all Department of Defense interrogations. With the passage of the Military Commission Act, we have ensured that all of our interrogations are fully compliant with the Convention Against Torture, Common Article 3 of the Geneva Conventions, and the War Crimes Statute. The Military Commissions Act put in place procedures that our nation can be proud of when it comes to prosecuting detainees for war crimes. I deeply regret that the Supreme Court ruling providing a constitutional right of habeas corpus to non-citizen terrorist suspects. I think this is a very bad decision for America. I think the American people are going to be deeply disturbed to learn that the mastermind of 9/11, Khalid Sheikh Mohammed, has the same constitutional rights as they do. As Chief Justice Roberts argued in his dissenting opinion, so who has won? Not the detainees. The court's analysis leaves them with only the prospect of future litigation to determine the content of their new habeas right, followed by further litigation to resolve their particular cases, followed by further litigation before the D.C. Circuit Court, where they could have started had they invoked the Detainee Treatment Act procedure. Not Congress, whose attempt to determine through democratic means how best to balance the security of the American people with the detainees' liberty interest has been unceremoniously brushed aside. Not the Great Writ, whose majesty is hardly enhanced by the extension to a jurisdictional quirky outpost with no tangible benefit to anyone. Not the rule of law, unless by that it is meant the rule of lawyers, who will now arguably have a greater role than military and intelligence officials in shaping policy for alien enemy combatants. And certainly not the American people, who today lose a bit more control over the conduct of this nation's foreign policy to unelected, politically unaccountable judges. Unfortunately, the administration did not want to give the detainees an inch. Congress eventually gave them a few hundred yards, and now the Supreme Court has given them miles. We have gone from one extreme to the other. As long as these investigations go on, I am confident that we will continue to find mistakes and uncover more poor policy decisions. But the overriding question is, have we learned from our mistakes? Are we all moving forward on a solid basis? The answer, in my opinion, is yes. The fact that the legal and policy decisions made from 2002 to 2005 were based on inadequate legal analysis used to justify harsh treatment of detainees is not new news to me. I don't think it is new news to anyone on the committee or anyone who has followed or revised any of the 15 or reviewed any of the 15 different Department of Defense investigations that they have been launched in the last 5 years or the numerous hearings held in the House and Senate. This committee alone has had 17 separate briefings and hearings on detainee abuses. Senator Warner is to be commended to making the difficult decision to have the committee fully investigate the Abu Ghraib scandal so that the American people and the world would know that when this country makes mistakes, it doesn't hide from them or cover them up. So respectfully, Mr. Chairman, we're not breaking new ground here. The abuses, the inconsistencies, the pattern of poor judgment in these matters are well documented. The fact that we have come a long way, the fact is that we have come a long way in the past 5 years. Secretary Rumsfeld is gone. Wolfowitz, Cambone, and Feith are all gone. and Jim Haynes are gone.